Thank you, Jonathan. I wanted to have a look this afternoon at the Centrica and Accenture case. This is a 2010 Court of Appeal case concerning Centrica, formerly known as British Gas, and Accenture, the well-known consulting company. Now, Centrica contracted with Accenture to design and install an automated billing system to serve Centrica's 18.8 million customers. Now, the contract contained the usual warranties that the system would be free from all material design, programming and implementation errors, as well as a warranty to the effect that the system would meet in all material respects specific requirements in order to give the capability to achieve a competitive advantage. Now, unfortunately, over a period of time, a number of problems emerged with this new billing system, and a number of customers' accounts were actually going unbilled, and other customers were getting billed twice for stuff they'd already paid. There was also a massive backlog of exemptions, and this is where Centrica had to manually intervene in the system before a bill could be issued, with approximately 18 million exceptions existing at one point. Now, inevitably, there was a significant decline in customer satisfaction and an increase in the churn of customers. The next slide, you will see the exclusion clause that was included in the contract. It's pretty familiar to most of you. It contains an exclusion for loss of profits or of contracts arising directly or indirectly, a loss of business or loss of revenues arising directly or indirectly, and thirdly, any losses, damages, or costs or expenses whatsoever to the extent that these are indirect, consequential, or punitive. The contract also included a definition of fundamental defects as a fundamental breach of warranty provisions which causes a severe adverse effect on the British Gas business. Now, when the system started going wrong, it became apparent that there was a major problem. Centrica notified Accenture in writing of the fundamental defects under the relevant clause. However, Accenture refused to take any action, arguing that it was under no legal obligation to do so because they were not, in fact, fundamental defects. So Centrica went ahead and issued proceedings. Centrica claimed that the overall design of the system contained two basic critical design errors, each of which were on a fundamental breach of warranty under the agreement and caused a severe adverse effect on the British Gas business and therefore constituted a fundamental defect under the agreement. Accenture said that a number of the items of loss which Centrica were claiming were not recoverable under the agreement due to this particular exclusion clause that you've got set up on your slides right now. Now, we regularly get asked what is indirect loss and what is direct loss and what is consequential loss. And to answer that question, we have to go back to the classic case of Hadley and Baxendale, which the judges also looked at in the Centrica case. Now, the Hadley and Baxendale case sets out two limbs of losses. The first limb being those losses which are fairly and reasonably considered as arising naturally, that is, according to the usual course of things, from such breach of the contract itself. And the second limb are the losses which may reasonably supposed to have been in contemplation of the parties at the time that they drafted the contract, and those are generally known as indirect losses. Now, just for your information, indirect loss and consequential loss mean actually the same thing and can be used interchangeably. So for each of the losses which Centrica suffered, the court looked to see whether it fell into either the first or second limb of the Hadley case. And what I'm going to do is have a look at the major heads of loss that were claimed by Centrica under the case and go through each of those and tell you which way the court decided that in the end they were going to fall either under direct or indirect loss. So the first loss was in relation to borrowing charges, and Centrica incurred additional borrowing charges of £2 million. This loss arose as a result of the fact because of the billing problems, and Centrica needed to borrow in order to make up that shortfall in the expected billing revenue. As a result of the additional borrowing, they also incurred interest payments. Now, the question was, were these borrowing costs indirect losses? And court took the view that they were indeed direct losses. This was primarily because the billing system was at the heart of Centrica's business and billing delays were bound to have an adverse impact on Centrica's revenue, with the very likely consequence that additional borrowing would be incurred in order to fill the gap, and of course additional borrowing naturally means additional interest. The second loss, which Centrica tried to recover, was the cost of chasing up the debts that were not in fact due. I have to say I'm actually quite surprised that Accenture thought that this was an indirect loss, i.e. had not been in contemplation of the parties at the time, but anyway, there you go. It was clearly a cost that was incurred by Centrica solely because of the errors in the system, which caused Centrica to have to chase the bills which had already been paid or were not otherwise due. And the court took the view that this was direct loss and didn't really analyse it any further. Now, the last set of losses I want to look at is that of ex gratia payments, and this is perhaps the most controversial aspect of the decision. Just by way of background, Centrica had decided that as a result of the severe disruption to the billing system and the resulting additional churn of customers, it was necessary for it to limit the reputational damage. As a result, it decided to pay in aggregate £8 million of compensation to its customers for poor customer service. This was entirely ex gratia. There was no contractual commitment to pay the customers at all. Now, Accenture took the view that this was clearly an indirect loss because it was ex gratia. In fact, the court took completely the opposite view and decided that it was direct loss. Once again, the court turned to the recitals of the contract and deduced from this that the purpose of the new billing system was to improve customer relations and customer services, and that Accenture had therefore assumed responsibility for this, given the fact that the billing system was having exactly the opposite effect with respect to customer relations. So basically, the court took the view that the ex gratia payments were in fact direct loss and were not indirect loss and couldn't be falling under that Section 16 clause which you saw on the earlier slides. I have to say this is perhaps a slightly worrying development from the perspective of the supplier. The key concern here has to be that there was no obvious limit on the amount that a customer might decide to pay in order to restore its reputational damage. Centrica chose in this case to pay £8 million, but it may have chosen to pay out £60 million, and on the basis of that decision, perhaps Accenture would have been liable in that case. Now, the last slide here that I've got is an exclusion clause drafted with the benefit of hindsight and is specific as a result of the claim between Centrica and Accenture, so it does only relate to the specific losses that were discussed and argued in this particular case. I have to say that when you read that through, I'll let you read it through, I think it's probably unlikely that Centrica would have accepted such a clause, and it probably would have been heavily negotiated, but that's a separate matter. This case and the case that Richard's going to have a look at in a minute shows you what is likely to fall under indirect and direct loss, but I have to say that it is very much fact-specific and will depend on what was in contemplation of the parties at the time of drafting the contract as well. With that, I'm going to hand over to Richard, who will look at the B-Sky B and EDS case. Richard.